The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future.
You're live.
Happy Tuesday, everybody. Welcome to Word on Wealth. This is Gary Quackenbush, your host, and we are here to rock and roll with you guys and teach you all things estate planning. That may sound boring, but I've got 3 cases of the week that have come up in a few, probably after we take our first little intermission, but some real things, real cases, real people. My job is very exciting. It's never boring on all the things I get to see every day. And some of them I have decided to share with you folks. And that way we can all learn together about the things that we should be doing with estate planning. Of course, you know, estate planning is something that everybody knows that they should have. One of the things I'm going to talk about tonight on the Andrea Kay show at 7 o'clock, she's invited me to be on her show a little bit tonight. And we're going to be talking about a very famous celebrity that recently died. Really a tragedy. We've kind of mentioned him before. But another celebrity, somebody that is surrounded by an entourage of professionals and, you know, people that consult with them. And you know that because they're worth, you know, millions of dollars, tens of millions, if not hundreds of millions of dollars. And then they pass away with no estate plan at all. Now, we always think we're invincible. I understand that, but I want to tell you this is the way I figured estate planning, the way it kind of works. So I was actually driving to the radio studio, and this was several years ago, in my Ford F-150 pickup truck, which I have now driven for 192,000 miles, had this thing since it was brand new. Driving down Miramar Road, the lady in front of the person in front of the lady in front of me, so 2 cars ahead of me, slammed on their brakes. The lady in front of me slammed on her brakes, and she couldn't get stopped quite fast enough, so she rear-ended the car ahead of her. Then what I ended up doing is I slowed down as fast as I could, and right before I hit her, I got rear-ended pretty hard. But I was able to, right after I got rear-ended, I turned and drove up onto the median. I have a truck. I can drive over trees, whatever. So I was up on the median. The thing that flashed through my mind was very interesting. I got hit. It was pretty hard. I knew the back of my truck was probably smashed, but, you know, it's big bumper back there and everything. And I got up on the median to get out of the way so I didn't get sandwiched between the car behind me. And what ended up happening is the impact. So explain the impact a little bit. The impact was hard enough that the person behind me, they got stopped, but the person behind them did not. And it was in a pickup truck loaded with a bunch of boxes, you know, cardboard boxes and tools and whatever. They hit the pickup truck hit the person behind me so hard that it launched all the boxes out of their truck all the way across Miramar Road, which would be 2 full lanes, up onto the sidewalk. It was incredible, like this catapult. He hit so hard and his truck lurched so hard that it actually chucked the boxes 2 lanes of traffic and landed on the sidewalk. So it demolished his front of his truck anyway. So I avoided most of the damage, but the first thing that passed through my mind, that's so appropriate, was I'm okay. And even if I'm not, I am insured because I have really good car insurance. You know, I think I have $400,000 of coverage on my truck. And then I have an umbrella that's a $2 million umbrella on top of that. So I just figured if something happened to me and I couldn't work or I got severely injured or whatever, I am totally, fully insured. And that was the thought that went through my mind. And I got thinking how that relates to this radio show today. And that is that when you have something in place, it gives you this comfort and peace of mind that things are taken care of. Now, I'm not saying on your, you know, on your deathbed, you're going to be saying, you know, oh, I'm glad I have my estate plan in place. Although I've heard from many people that that's exactly what they felt like. Things are in place. They didn't have to go and rush out and take care of business. It was already taken care of. But the nice thing is being prepared because it's inevitable. The other day I was riding and, you know, got into I ride mountain bikes all the time. I wear a lot of gear, full face helmet, the whole thing. But I ended up on a trail that I've been on many, many times, like dozens of times down this trail. I was a little bit relaxed, should have been a little bit more, on the ball. And I hooked a pedal on a bush and it threw me over the bars with my bike. And I landed kind of around my bike on my face and ended up in the hospital. And that startled me. And I went, oh my gosh, I know this sounds funny, but what if I died? Am I ready? And it literally made me reevaluate. And I'm not saying that I would have, if I didn't have all my gear on, I could have, but it made me rethink like, wow, life is too short. We always say that. We say life is too short and it stinks getting old and all that stuff. But when you kind of face those moments, I think there's reevaluation. So I've been kind of going through this little reevaluation of myself to make sure I do want to amend my trust because we're going to change a couple of things, so just to kind of tweak it a little bit. I put my trust together 23 years ago, and I've amended it in the meantime, but it's like, I'm looking at it going, you know what, Gary, you should restate your trust. Just do a new one. That's what I tell clients a lot of times. If a trust is super old, don't worry about it. Should we amend it to change the language? Just do a new trust with the updated, latest and greatest. My distributions are fine, but I've got a lot more grandkids now than I did last time I amended. I'm going to change. So I'm kind of in this mode now of rethinking and retweaking. And I think that's good for all of us. So you are listening to The Word on Wealth. We're talking about estate planning today, wills, trust, power of attorneys, administration, and probate. And the number to call me at the office if you want to consult with me, get your free initial consultation, mention this show, 855-500-TRUST. If you have a question for me on the air, I would love to answer your question on the air. The number is 888-344-1170. One more thing to remember.
2 minutes.
My website, gqlaw.com, has a bunch of free stuff on it. It has free designation of guardian. So if you're going to nominate a guardian, like let's say you didn't have a will or a trust and you're planning on leaving your kids and going on some trip somewhere and you don't have a will or a trust. Okay. You know how I feel about that. Not going to say it on the air. But for crying out loud, at least do a nomination of guardian. And that is, it says, in the event of your deaths, you don't return from that awesome fancy vacation, then you name the guardian. And if you don't do that, your children end up in Polinsky Children's Center in the middle of a court battle with people in your family fighting over who's going to be their caretaker. Seriously, bad idea. I have on my website, it's free, and I don't even have it connected to anything, so I can't even tell whether you got it. So it's for free. It's called a nomination of guardian. You go on my website, there's a tab that says free stuff. You click on nomination of guardian. It downloads a PDF. You fill it out. I'm not going to tell you how to fill it out. You figure it out yourself. But if that's all you've got, it's better than nothing, because nothing, when you have minor children, is awful. And I know I'm making it sound bad, but I'm not exaggerating. It's awful. Of all the stories I could tell over 30 something years of doing this, the absolute harrowing stories that I could tell all have to do with botched guardianship designations or no guardian designation or kids going through the guardianship process. It's brutal. If you have designated who's going to be your guardian, you've nominated them, or you have a will or part of your complete estate plan, you've nominated the guardians, it's 100% better. It just is, because they have legal priority. You're listening to The Word on Wealth with attorney Gary Quackenbush. To be part of the show, we got lines open, 888-344-1170. If you want a free consultation with moi, you can call 855-500-TRUST, and I will be happy to set you up with an appointment to see me, 855-500-TRUST. If it has to do with taxes and tax problem solving, you're going to talk to Rich. He's awesome, 855-500-TRUST.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christians just don't understand that the money they save for retirement usually helps fund the abortion industry and other liberal anti-family causes. But did you know that with just a few minutes of your time, we can screen and clean your investments at no cost to you? It's absolutely complimentary. Just go to the website right now, download a free copy of my book, Faith-Based Investing. It's free as well. You deserve to know the truth as the investor. Then the choice is yours. You can keep doing what you're doing, or you can line up your investments and life savings with your beliefs. We are fiduciary investment advisors. You can feel good about investing with confidence. So learn more now. Go to BibleSafeInvesting.com or call me at 931-RETIRED. Your free book is waiting for you. Go to BibleSafeInvesting.com and be sure that you listen to Faith-Based Investing this weekend right here on Family Talk.
So Gary, we've talked a long time about estate administration. So what is that and why is it important?
Estate administration is the distribution part of estate planning. So when someone passes away and they leave money to beneficiaries, the property has to be administered. So it's like taking it from the decedent to the survivor. That's called the estate administration process. So usually you're going to have a successor trustee that's named in the trust. So have no idea what they're doing because they've never done it before. So then they call on GQ Law and we walk them step by step on how to.
By the way, your offices are, since I was there with Craig, they're in a really cool spot.
On Well with Gary Quackenbush of GQ Law. Call or click to request your free. Call Gary at 855-500-TRUST. GQLaw.com.
You're live.
Right. It's that time, ladies and gentlemen, for the announcer to step in and
Announce that this is indeed the Word on Wealth Gary Quackenbush GQ Law case of the week.
Thank you, Noah. I just really enjoy doing these legit, real things that happen. Okay, so here's a good one. 3 adult children. The son is the successor trustee, and he's got 2 sisters. The successor trustee, after mom died a long time ago, then mom died. He felt like he wanted to make sure that mom's house was in prime shape. I don't know why. I think part of it, I guess I actually do know why. Part of it is he was a little embarrassed that mom lived in this house and it got really run down. It was very dated, 40-year-old furniture, 40-year-old cabinets and countertops. And it just looked like an old house with an old person. And he really felt like he wanted to do his mom right and spruce it up, bring it up to speed, and then sell that house and make a profit for the trust. Well, what happens in a case like that, in this particular case, he wanted to save money. And so he worked on some of the upgrades himself. He was working full time. So he's trying to do nights and weekends, working on some of the upgrades, helping the contractors do it. $100,000. And 1.5 years later, the house was ready for sale. Okay. Whose money was the $100,000? Answer, Yep, it was the trust money. It belonged to the trust. The trustee's job is to maintain value in that trust. Spending $100,000 on upgrades on real property, I will tell you, that is not maintaining or sustaining value to that trust, because there's absolutely no guarantee, one, that the upgrades will actually increase the value of the property by the amount that they spent. Now, I know there's statistics and say, well, if you add a kitchen for $50,000, you can get another $100,000. Great. So you can net 50, or if you put in a bathroom and spend $15,000 in a bathroom, it'll increase the value of the house by $15,000. Well, that's zero. And in the meantime, in a year and a half, what if he took that $100,000 for upgrades and the value of the house sitting in an investment account somewhere? What would have happened? Well, here's the disaster. During the time that he was doing the upgrades, he got stuck in the middle and the market dropped. Okay, we've recently seen that here in San Diego, but in this case, the market had dropped and the value of the house was, we could easily show the drop in the value of the house was around $150,000 to $200,000 during that year and a half. All we had to do is get an appraisal saying, what was it worth, a year and a half ago? And we know what it was worth on the date of sale. So the problem he had was he spent $100,000 on upgrades and the house value, and the house sold for $150,000 less than it was worth at the time mom died. That's $250,000. Whose fault is it? Who takes the loss? Who's responsible? The successor trustee's job by law is that they must reduce the risk of loss. They have to reduce the risk of loss. They have to maintain the property value as best they can. They've got to act in good faith. So the problem with this successor doing what he did is he didn't reduce the risk of loss. He increased the risk of loss because he took the house off the market. It wasn't rented out for a year and a half. It could have been rented the whole time. I mean, even if he just decided, oh, let's just speculate on real property and hang on to the house, at least he would have rented it out. He still would have suffered the $150,000 drop in value, but he at least would have had rents. Would he have had $100,000 in rents in a year and a half? Probably not. So the penalty is that this successor trustee needs to make the trust whole. So we had to go through a calculation to try to figure out, had he just, mom passes away, spend, $10,000, $15,000 on just kind of freshening the house up, maybe redo some of the carpeting with some just carpet that looks good. It's going to be torn out by the new buyer anyway, and just make it so that it looked good. Leave it dated, but make it look clean. He could have had the house on the market and probably sold within 3 months, but it took 18. So in the meantime, he's now got to make the trust whole. So we go through the calculation. House value dropped by 150. Well, what if he had to sell? What if he sold it within 6 months? Would the house have dropped that far? Maybe, maybe not. But he spent $100,000 on upgrades. And if the house didn't go up, if the house were worth $500,000 on the date of death and he put $100,000 in upgrades and it sold for $600,000, that's still zero. It's still zero, because yeah, you would have got more money, but it's still zero. So that was a breach of fiduciary duty. So what we ended up doing, the sisters were really mad. So we ended up going to probate court to get a determination on the successor trustee's breach, which was that he just took too long, was irresponsible with the money, made really bad financial decisions that he wasn't entitled to make. And we ended up, we had to resolve it. We had to settle it. But, basically the trust took a $250,000 loss under his watch. And it was something that could have been easily avoided. But then when he was stuck in it right in the middle, now you can't sell the house because upgrades were costing more and more money, but he was spending trust money. So anyway, I think that's one. It's my opinion is it is just better to distribute as soon as you can. Don't worry about upgrading the house. Don't worry about that, because remember, there's not going to be any capital gains tax on that sale of that property. Even if mom and dad bought the house for, $20,000 and now it's worth $600. If they sold it, they would have had capital gains issues. But if you sell it, no, because the capital gains, the basis to calculate capital gains increases to fair market value. You get a new basis on the date of death. So as of the date of mom's death, there is no, if they sell it the day after mom dies, there's no capital gains tax, which is incredible, because that could be 25 or 30% sometimes. Okay. The second one. So I wanted to go into a second case of the week. By the way, if you want to talk to me about it, if you want to call and ask questions on the air, I've got lines open. I'd be happy to take your call, 888-344-1170. If you want to talk to me, go to my website, gqlaw.com, and contact us there, or you can call our phone number, 855-500-TRUST. The next one I wanted to talk about is case of the week number 2. Mom's trust said house goes to all 6 kids. When mom passed away, the kids didn't want to share the house. One wanted to buy the others out. What's going to happen? Because the trust specifically said my house, and so it addresses the asset specifically, that the house goes equally to the children, then it made it so that they all inherited 1/6 of that property. So for the property now to be sold to one of the beneficiaries, one of the siblings, they would actually be buying the property from the other 5. So whatever deal would be worked outside of the trust because they had to take it. Now, a big challenge is the property tax issue. Even if the other kid, even if one kid ended up with it, so it looks like it was mom died and it goes to this one child who ended up, getting enough money to buy everybody else out. Does that qualify for a parent-child exclusion? No, because the trust said, give the house to my kids. If it said everything I own goes to my kids, that would be a completely different story. But because they each inherited 1/6, the property tax was reassessed on 5/6, right? The 5 children that didn't live there anymore. And then the one child that now lives there, he gets his 1/6 value of that property stays, the property taxes on that 1/6 stay down to, at where they were when mom died, because that's under Prop 13. So that's kind of the sad thing. It was a parent-child exclusion. It would have qualified had they if it just said everything I own to my 6 kids, and then the one that wanted to buy it goes and finds a bunch of money to put enough money in that trust to pay cash to the 5 kids and then give the title to the other, then you could have probably worked it out to where the property tax would not have been reassessed, because that would be parent-child exclusion. Pretty cool, huh? So sometimes you got to be careful what you're setting up. Maybe get some professional consultation to figure out, what's the best way to go. Is there some tax consequence to watch out for? Sometimes they're a little tricky to figure out, but they are possible to figure out. So that's what I recommend. If you're going to do stuff like that, talk to somebody ahead of time. Okay. So what I'm going to do coming up next is I want to talk about some basics of estate planning that I know we talk about them a lot. I get that. But I think unless you become interested in it, or it is important to you at the time because now you're maybe in the middle of it, that's when things like this become important. What I'm going to talk about next is called funding. It's how to put money in your trust. I get questions about it literally every day. There's a lot of misunderstandings of what funding really means, and we're going to talk about that. We're going to talk about anything, putting anything in the trust. I want to tell you how it works specifically. And then if you want, you can, get out your own trust documents if you have them. And then you kind of go through things as we talk you through it and see whether your stuff is complete. If not, then there are ways that we can get it fixed, like change the funding or retitle the house, or, teach you how to do bank accounts. But that's what we're going to teach you guys next on the Word on Wealth. Okay. Other things coming up today: 10 documents you have to have in your estate plan. What if you don't want to give all your money to your kids? I know the kids are like, oh, don't you dare talk about that, Gary. But we're going to talk about it. What are other things you can do with your money besides giving all to your kids? So briefly, one thing I do want to address really quickly is co-trustees. I get this a lot. Gary, should my kids be co-successor trustees? And I don't mind the idea, the concept, the thought that you want your kids to work together and, and to love each other, and that, and work it out. I think that's a great idea. But I think having them be co-successor trustees is not a good idea, because it's not going to be something that you, it's just going to, It's just not going to be a good idea. Okay. Because what happens is then you have all of your children are trying to decide together on what to do. Now, I don't know if your children could all decide together. I would not want to put my own kids through that where they all four had to agree because they're going to have differences of opinion. They love each other. They're great. They get along really well. But if I'm having all four make every decision, it's really difficult. So I don't really like co-trustees. However, if the trust is like an AB trust or there's some, like a blended family type thing, then I think sometimes it's a good idea. It makes it more of a hassle, which is probably a good thing. But you have like one member, a co-trustee from each family. So you have mom's family and dad's family. You'd have, pairs of co-trustees. Like the kid from dad's family has to work with the kid from mom's family. So that way, at least there's the checks and balances to make sure that the estate is being preserved and not just used up by, whoever's getting their hands on the money. So to be careful with that. All right. So co-trustees, Gary doesn't like it. It is possible. I still have people trying to talk to me into it and say, but Gary, I think this is the best thing since sliced bread. And I do my best to talk you out of it. If there's any other way around it, don't do co-trustees. But if you have to, you can't really do anything wrong. This is Gary Quackenbush on the Word on Wealth. We'll be back in a minute.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST. Go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-5.
You're live.
And here you go. Give us a call, 888-344-1170. Friends, we have lines open. I'd love to hear from you. Ask me a question about estate planning, wills and trusts, and all that kind of stuff. That's what we're going to be talking about for the rest of the hour here. Okay, so let's start out with putting stuff in a trust. The trust itself is, I always think of it as a box because it's just kind of, so let's just say your living trust is a box. And that's where you're going to put all of your stuff. If it's in the box, whoever is hanging on to that box is in control of it, right? If you put in a car and you put in your, if it's a, let's just have a toy box. You have a car, your Legos, you have the playhouse, you have stuffed animals, whatever's in that box. If I'm hauling it around, I'm in charge of it. Okay. That's what our trust is doing. Our trust is a box, and we have to put things in that box. The person that is hanging on to that box that's in charge of what's in there is the trustee or the successor trustee. Trustee meaning you, because you created the trust and now you're also managing it. You're the trustee. Once you become incapacitated or pass away or resign as trustee, you are no longer the trustee. There is a successor trustee named. The trust will stay.
We have a caller. We have Rob from San Diego's got a question on trusts, Gary.
All right, Rob from San Diego. Welcome to the Word on Wealth. How you doing, Rob?
Hi, Gary. I was just listening to the radio and listening to you. I do need help with a trust. I'm not Bill Gates, but I have quite a bit of money to be left to my 2 children, and I don't want to give them the money when I kick the bucket. What I want to do is leave a perpetuity trust that all they can withdraw is the proceeds that the trust produces, and it'll be invested in the stock market, etc. Is that something that you do, or can you advise me on who can do that for me? Because I don't want to leave them just millions of dollars to play with. I want to provide a floor for them that they can draw once a year a certain amount of money from the trust, from the proceeds of the trust.
Mm-hmm.
They cannot touch the capital.
And then what is your plan with the capital after you've passed away and after your kids are old and gray? Then what's going to happen to the money?
Well, that's what I thought a perpetuity trust. They are going to be responsible for naming the inheritors of the benefits that they were enjoying when they were young and sprite. Okay, but it's a perpetuity trust, they call it. I think it's a perpetuity trust. I know people with I don't have hundreds of millions of dollars, but they're about a lot of money. It's millions. And I don't trust them to manage the money. I want to name a lawyer. I want to. I need an accountant to pay the taxes on the trust, and somebody who will manage the trust or adhere to the wishes that I left in the trust. As far as disbursement to my heirs, I don't want anybody that doesn't have my last name, my blood, to inherit one dime. Okay, I want my blood relatives into the future to inherit and actually withdraw funds from the proceeds of the trust. I live in California. I know I know that there are different rules in different states as to perpetuity trust, and some states are 100 years. States are 22 years. I've been just reading a lot on it, but I need help.
Okay. Well, and that's something I'd be able to help you out with that. Like, anytime you set up something like a perpetuity trust, or sometimes we call it a Kennedy trust, where you try to get it to where it goes multi-generational, they're very, very complicated because the government doesn't really want you to do that. They don't want the money to be floating around outside of the tax system for that long. So they're complicated. They can be done. And you're right. It depends on how the trust is set up. The thing with perpetuities, there's a thing called the rule against perpetuities, and that it's to set up a trust. If you're going to go beyond the rule against perpetuities, which is at your death, the whoever is alive at the date of your death, the last one of those that dies, the trust can't go beyond 21 years after that, or it has to just collapse. It has to pay out all of its money, or else the trust becomes illegal at the beginning. So there are ways you got to watch out for that, but there are the multi-generational trusts that can be set up. Usually when I do that, I work with a good friend of mine who does that kind of work. very specifically because they're super technical. A lot of fun to do because you're kind of you're setting up kind of like this family company, this money generation machine that's going to benefit your family for generations to come. But you can give me a call on something. I'd be happy to talk to you about that. Figure out how we
At
can.
this phone number?
855-500-TRUST. It's 855-500.
855
500
500.
TRUST.
Yes.
TRUST.
Trust, TRUST.
Yep.
That's more, one number more than said. That's area code 855 500, and then TRUST.
Correct.
That's more digits than.
You're
It
right.
doesn't matter.
You're right. And if you that's our phones cut it off after 4 digits. Yeah, you can keep putting in the last number 15 times if you want, and it'll still just call the first 10 digits. So yeah, 855-500.
I understand. When do I call you? Gary?
You can call my office now if you want. And I've got secretaries there. They can set up a time to talk, for you and I to talk. So call now.
Yes. What is that number? I called 888.
No,
the number you just gave me.
The number I just gave you, that's my office call line. 855-500-TRUST.
Okay. So that's you have people there that can actually schedule an appointment or a talk between you and me.
I do. Yep.
Thank you, sir.
You bet. Good to talk to you. Thank you, Rob, for your call. Appreciate you being part of the show. All right, guys, we're going to continue. What we are going over is trying to figure there are ways to put stuff in a trust that needs to be done right. Because if it's not, then there's ways we can do it after you pass away, but it just costs a lot more. It's a lot more hassle. So basically, it's nice, to have Rob call. I appreciate it. Talk about his perpetuity trust and how to get multi-generational. Those, they get tricky, but they are totally possible. If you want to ask me a question, call on the air. We got lines open, 888-344-1170, 888-344-1170. Call, ask me a question right here on the air on the Word on Wealth. The concept of the trust then is like having a box, and the person holding the box, person that's controlling it, the person that gets to put the lid on and take things in and out of the box would be like your trustee. Okay, it's one way to think of it. So how do you put things in a box? The house is probably the most straightforward. And when you do a complete estate plan through an office like mine, and through most estate planners that know what they're doing, is the job of the estate planning attorney is to deed the house to the trust. So the title, instead of it saying like Gary and Cheryl Quackenbush, it'll say Gary and Cheryl Quackenbush, trustees of the Quackenbush Family Trust. So the house gets deeded to the trustee of the trust specifically. And you can, if you want to know whether your house is in trust, if you've had your house refinanced, whenever, a lot of times after the refinance, they do not put the house back in the trust. They'll take it out, but they won't put it back in. So that might be a reason that you need to have your house put back into the trust now. And that's super important, because if you pass away or become incapacitated and your house is not in the trust, it's not controlled or dealt with by the trust. And that's a problem. It'll go through probate court, judges, attorneys, expenses, all that stuff. So to avoid it, you got to put your stuff in the trust. How should you do with a deed? Life insurance, another easy one. Go to your life insurance company. You can sometimes do it online, or you just do it by calling them, and you make it so that the beneficiary of that life insurance is your trust. They're going to have a specific form. What's the name of your trust? When was it created? Is it revocable? Yes. Did you create it yourself? Yes. Are you the first trustee? Yes. So that's the way you do it. So the life insurance on death pays out to your trust. Other things like bank accounts. That's another big one. To get a bank account in the trust, you go to the bank and you open a new account in the name of your family trust. So when you go to the bank or credit union, you call them up ahead of time, try to schedule a time, and just say, I have a living trust. This is important. I have a living trust that I have just created, and I want to get a bank account in my living trust. Can you help me? They'll schedule a time and you go in. Sometimes they get confused if you say, I want to set up a trust account. You're not setting up a trust account. You're setting up an account in the name of your trust. Okay. If you say you want to set up a trust account, sometimes it gets more, that's a different thing, but just tell them, you don't have to know all the terminology. Just say, I have a living trust. that I just got created, and I want to open up a bank account in this trust. And then they will help you out. That means if you open an account in the name of the trust, any money that I put in that account is actually in the trust. So I open a savings account. I put in my $1 to start it up. If you go to credit unions, they don't even require $1. But then when I go home, I have my accounts linked between my regular accounts and my trust accounts, and I move my money from my own named accounts to my trust. That's the way you fund it. There's a couple other things we need to go over, like businesses, stocks, IRAs, stuff like that. I want to talk about coming up next here on the Word on Wealth. We'll be right back.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQLaw.com.
Gary, your team at GQ Law are experts at solving IRS and state tax problems. Talk about that.
When people have a tax problem, it tends to really stress them out. And one of the things we've been able to do is figure out how to resolve tax problems. One thing we might be doing is setting up a payment plan or getting a collection delay, maybe getting a determination that the person shouldn't have to pay the taxes at all. We do offers and compromise. We do auto reconsiderations. And one of the things that's a really powerful tool that some people don't recognize is sometimes bankruptcy can be used to actually eliminate taxes when there's certain conditions of the code that are met. So we can do all kinds of things. After we analyze your situation, we can figure out what's available, discuss your options, and figure out which ones to implement, what it's going to cost, how long it's going to take. And we can get people out from under all kinds of tax problems so they can sleep again. That's our goal.
Request your free initial consultation. GQLaw.com. 855-500-TRUST. GQLaw.com.
What
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
Right. Happy day, friends. Thank you for being here on the Word on Wealth. We're in the middle of a discussion, and hope you've been tagging along on the discussion about putting money in your living trust. So your living trust is like your box, and whoever's hauling that box around, whoever has the control of that lid is the one that's controlling the assets that are in there. I like to think of a trust as a box, or treat it like it was a corporation, or treat it like, there's all different ways. I mean, I do it as a tank, like a water tank or an aquarium, but it's a receptacle. So to get money in there, you've got to be careful. A house, we went over, obvious. Life insurance, change the beneficiary designation. Cash, business, bank accounts. Go to the bank, open an account in your living trust, get a checking, get a savings. You can get a money market, a CD, whatever. What about your investment accounts? Same thing. Okay. Now, if your financial advisor doesn't know how to do that, that's crazy to me. But I've had financial advisors call me and say, "What are you talking about? Just, just do a transfer on death designation or a pay on death designation. That way, when they pass away, the money's going to go to the beneficiary." Well, it's true. If you do a pay on death designation or transfer on death designation, you're right. You don't have to change the account. It can still say Gary Quackenbush. And if you look at it, it says when Gary dies, give the money to Cheryl or give the money to the kids or whatever. But if you do that, you won't have access to the money if you're still alive and incapacitated. Because anytime you need to get money out of a bank, you have to have capacity to do that. You have to know what you're doing and pull the money out. Now, if you are incapacitated, incompetent, like literally, ill, and your dementia has got to the point where you can't manage your money or handle money or manage finances, and you've got magazine subscriptions out for the next 15 years, and you're writing checks to every sweepstakes that says that you've won. When that starts to happen, you've lost it. And I'm sorry, but that's a bad thing. And it's unfortunate, but it happens to so many people. So if you have your money, your investment accounts in your name that says, when I die, give it to so-and-so, great. But what if you need that money and you're incompetent? If you're incompetent, you cannot access your money. So you have all this investment money that you've saved up for your whole entire life that's sitting in your personal name that says, on my death, give it to my kids. Well, you're not dead, but you need the money. The best way to hold the investment money is in a trust. And my financial advisor wouldn't have it any other way. It was, just crazy. I said, okay, I have some money. He says, okay, give me your trust. Give me the name of your trust. They set up the account in the name of my trust and said, okay, now where's the money? And they went and got the money from an investment advisor that I was using that I'm not super thrilled with, and they moved the money. And it went from an account in my name to an account in the name of my trust. I'm very happy about that, because if I am incapacitated, who has access to that money? My wife does. If we're both incapacitated or dead, who has access to that money? The successor trustees. Okay. It's awesome, but it's work. Okay. But it's something you got to do. I was told by this super awesome person, this was a church leader, and it was interesting. We were talking about, work is hard, and, effort, things require effort and all that. But one of the things that he said is you have to take the time to do the things you need to do along the path. You just have to take the time to do the things you need to do. Estate planning, putting your stuff in your trust. If you already have an estate plan, these are things you need to do. What about furniture? How do you put that in the trust? What about jewelry, heirlooms, collectibles, photo albums? There's no title to those. So we can't change the title and, on the bottom of the furniture, say this furniture belongs to Gary and Cheryl's trust. You could, not really necessary. What we usually do is I figured out how to do a thing. We call it a personal property assignment. And it says that you assign all of your personal property to your trust. And then I do another document that's a little bit of a duplication. It's a comprehensive transfer, where it says we comprehensively transfer all of our property, wherever located, whatever kind of property, whether it's real or personal or intellectual, money or otherwise, all that stuff gets transferred to the trust. So what we've done is we've effectively assigned title to all those things, assigned ownership to the trust. That way, after we die, the trustee has the ability to say, this is all my stuff to distribute to the kids. Now, obviously, furniture, chair, jewelry, heirlooms, those things, whoever has them in their hand owns them. So you want to make it so the successor trustee knows where everything is so that they can put their hands on it and distribute it to the beneficiaries. Okay, so that's furniture. Items like jewelry, heirlooms, collectibles. We're not talking about giving them away or distributing them. We're just talking about how to get them under the control of that trust. What about gold, contents of the safe? There's no title to that stuff. So what you want to make sure is there's some instructions for the successor trustee. Hey, trustee, this is my safe that's in the closet. The key is under the door. The key is somewhere, or here's the combination. So that they can get into that safe, because if it's got gold and silver and jewelry or something in that safe, none of that has title. That's going to be distributed as part of the distribution plan of this trust. Okay, tricky things. What about cars? People are constantly told, oh, don't put your car in the trust. If you put your car in the trust, it's very helpful. It means that you don't have to wait 40 days after death to be able to get rid of a car if you need to get rid of a car. So I love to put cars in trusts. That's something you do at the DMV, and the DMV basically has a form that you fill out, and you're changing the title, goes into the trust. So take some time. It's not super easy, but it's doable, and it's important, because then when you pass away or become incapacitated, your successor trustee has the ability to sell the car for the cash that you need, or if you don't need it because it's sitting there, you're not going to drive anymore because you're in independent living or something like that, then it can be sold and you don't have to worry about it. Okay. One last thing, and that is, or two things, businesses and IRAs. How do you put an IRA in a trust? Answer, you cannot. The IRA or a rollover IRA, you may have had a 401k or something at your work that now has been rolled over to an IRA. That cannot be put in a trust. Think of the IRA as a trust in and of itself. It's held because it's qualified money. It's money that hasn't been taxed yet. And as soon as that money comes out, it gets taxed. So that's why they don't just let you have it in your checking account, because you'll forget to pay the tax. So with the IRA, there's a commitment. If it's an IRA and it's tax deferred, the IRA custodian has a legal obligation and a commitment to the government to report that there's been a distribution, so that they can make sure you put it on your tax returns and pay the taxes. But if you don't want that IRA, like the caller that we just had saying, I don't want my kids to have all my money because they won't know what to do with it. That happens with IRAs. Do you want your kids to inherit all of your IRA money so they can just spend it? What I usually recommend is make it so that the IRA beneficiary, if you have no surviving spouse, the IRA beneficiary would be the trust for the benefit of that beneficiary. So it's going to be like, Gary Quackenbush, for example, let's just say it's John Brown, successor trustee of the Jacobson Family Trust for the benefit of Julie Jacobson. So that way you've gone through this designation that it's going to go to the trustee for that person to handle it as trustee for the benefit of the beneficiary. And that way it makes it so that you can take that money from that trust or from the IRA, you can take it out over 10 years. You don't have to pull it out all within 5. If the trust isn't set up right, the beneficiaries aren't done right, if the trust is not set up as an IRA conduit trust or a retirement protection trust, then the money has to be pulled from the IRA in 5 years. So it gets taxed twice as fast. If the trust is set up right, and if it's not, we can amend it. Just call me 855-500 trust. Just call me and we can amend it and make it so that it's an IRA trust. And that way the beneficiary designation of the IRA goes to the trust for the benefit of the beneficiaries. So the trustee now, the successor trustee, has the ability now to control that money. So if there has to be a required minimum distribution, the successor trustee grabs that money, puts it in the trust. Because if you leave minor beneficiaries or beneficiaries that you don't want them to have money right away, you want them to just, when they're 35 or 40, then they can have money. You can make it so the IRA falls under those same rules if your trust is done right. So I'm happy to help you with that, talk you through it. That's the way I do it. All my money, I don't want it to go straight to kids. I want it to go into my trust so it can be controlled by my trustee as far as spending and speed of payment. 855-500 trust is my number. We can talk about that. Businesses, putting a business in your trust is awesome. You take the stock certificates and you reissue them from the corporation, you reissue them to your trust. Why would you do that? Because once you become incapacitated or pass away, what's going to happen to your business if you're not running it? It might be, it might get, somebody might come and steal it, or, somebody might take all of your customers. The customers might be all upset. But if you transferred it to your trust and now the successor trustee has the ability to control it, they can hire the accountant, the attorney, the contractor that was working for you to close the contracts. They can sell the business. They can wrap it up because it's in your trust. If it's not in a trust, who's going to be the one wrapping it up and doing all the cleanup of the business to make sure the customers are happy and to make sure that there's money still coming in, or that, you're going to transition the business or sell it? That can be done if it's in the trust. It can be done by the successor trustee. To get that business in the trust, the simplest way is, if it is a corporation, we transfer the corporate stock to the trust. If it's an LLC, we transfer the membership interest. This is all stuff that works great, you guys. I'm glad you're listening along. I'm glad we are talking about this stuff. It's important. 855-500 trust is the number to call, and hopefully we'll be talking to you soon. Talk to you tomorrow. Talk to you tonight on the Andrea K Show at 7.
Tell a friend about the Word on Wealth, featured since 1995. With financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future.
The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinions expressed here do not necessarily represent the views of Salem Media Group or its sponsors. The Word on Wealth with Gary Quackenbush is sponsored by the Word on Wealth Radio.
All right, bud. What do you want to talk about with Andrea?